Your buddy just handed you $5,000 in cash to buy into your landscaping business, and you shook on it. Now he wants out, he wants his money back, and he is telling everyone that the deal never counted because you didn't sign anything. You're staring at the ceiling at midnight, wondering if you actually have to pay him back or if he is just blowing smoke. There's a massive myth out there that a deal isn't real unless there's a giant stack of signed papers involved. People think if there's no contract with a bunch of legal jargon, they can just walk away. But that isn't how the law actually operates. A handshake deal can absolutely be legally binding. It can drag you into court and completely clean out your bank account. We're going to dismantle this myth piece by piece so you know exactly where you stand. To understand why this myth is completely wrong, you first need to understand what a contract actually is. A contract is just a legally enforceable agreement between two or more parties. Notice that the definition doesn't say anything about paper, and it doesn't say anything about ink. To have a valid contract, the law usually only cares about three basic things. You need an offer, which is just a clear proposal. You need acceptance, which means saying yes to that exact proposal. And you need consideration, which is a legal word for the exchange of something valuable like cash for a truck or labor for materials. If you have an offer, acceptance, and consideration, you generally have a deal. When you and your buddy shook hands, he offered to give you $5,000 for a share of the landscaping business. You accepted the offer by shaking his hand. He handed over the cash, and you accepted it. That right there's the valuable exchange. That's consideration. You just formed a contract. The physical handshake itself doesn't have magical powers. The magic is in the fact that you both agreed to the terms and exchanged something of value right there in the moment. But because there's no paperwork, you're going to run straight into a brick wall called the Statute of Frauds. The Statute of Frauds is a very old legal rule that says certain types of agreements must be in writing to be legally enforceable. If your deal falls into one of these special categories, the handshake doesn't matter at all. You can wave your empty hands around all you want, but the court won't force anyone to do anything. Let's look at what actually has to be written down. As a general rule, any agreement involving real estate has to be in writing. Real estate just means land and anything permanently attached to it, like a house or a barn. If your neighbor says he will sell you an empty lot for $10,000 and you shake on it, that deal is completely meaningless in court. The law considers land too important to transfer with just a spoken promise. Another big category involves agreements that can't be finished within 1 year. If you agree to work as a foreman for someone for exactly 18 months, that deal has to be in writing. Because it takes longer than a year to complete, a judge won't enforce a spoken promise. The same rule usually applies when you agree to pay someone else's debt. If you tell a mechanic you'll personally cover your brother's repair bill if his check bounces, that promise normally needs to be written down. There's also a rule about selling goods worth more than $500. Goods just mean physical, movable items. A car, a riding lawnmower, or a pile of lumber are all goods. If you agree to sell an old tractor to a guy for $600 and he breaks the handshake deal the next day, you generally can't sue him for breach of contract. A breach is just the legal term for breaking a legal promise. Because it's a physical item over $500, the law usually demands a signature. These rules vary by state, so the dollar amounts and specific timing can shift depending on where you live, but the overall concept is exactly the same everywhere. So, what happens when your deal doesn't fall into one of those special categories? Let's say you agreed to sell your buddy a used lawnmower for $300. You shook on it, he gave you the cash, and then you decided to keep the mower and keep the money. He can absolutely sue you over that handshake deal. Let's say you agree to fix a guy's roof for $2,000. No signature, just a handshake. You show up the next morning, tear off the old shingles, and lay down 3 rows of new tar paper. Then the homeowner changes his mind and tells you to get off his property. He might think he doesn't owe you a dime because there was no written contract. But he is completely wrong. You tearing off the roof is partial performance. Your physical labor is clear circumstantial evidence that a deal existed. A judge will look at the bare roof and force the homeowner to pay you a reasonable amount for the work you actually completed. This is exactly how tradesmen get paid when they work without signing formal documents. You've to remember that contracts aren't a magical language reserved for lawyers. A contract is just a promise that the legal system is willing to back up. The system doesn't care if you signed a document with a heavy fountain pen. The system only cares if both of you intended to make a deal, if you agreed on the basic terms, and if you traded something valuable. The reason people believe the myth is that proving a verbal promise is a massive headache. It's incredibly easy for a liar to say, "I never agreed to that." The law doesn't want people lying in court. That's exactly why the rules exist. But if the other side gathers the right text messages, pulls the right bank records, and proves they delivered the goods or started the labor, the court will enforce that handshake agreement. You are fully bound by your word. The biggest danger of a handshake deal isn't that the deal doesn't count. The danger is that the terms are incredibly vague. If you and a buddy agree to flip a house together and you just shake on it, you might think you're 50-50 partners. But what happens when the roof needs $10,000 in unexpected repairs? Who pays for that? Without a written agreement outlining exactly who pays for what, you end up in a massive legal battle. The court has to guess what your intentions were, and judges absolutely hate guessing. You might be wondering how you protect yourself when you're doing business in the real world. You get things in writing. You don't need a 10-page legal document drafted by an expensive lawyer to make a deal. You just need a basic paper trail. If you're making a deal in a parking lot at 10 o'clock at night, send a text message immediately afterward. Say, hey, just confirming our deal that I am buying your welding machine for $400 and I will pick it up Tuesday. If the other guy replies with yes or sounds good, you just locked in an enforceable contract. You created the exact proof you need. If you ever find yourself staring down a broken handshake deal, you need to know when to call a professional. You should absolutely talk to a local attorney if a lot of money is on the line. Laws change depending on where you live, and a local lawyer knows exactly how your specific judges handle verbal agreements. If someone is threatening to sue you over a spoken promise, gather every single text message, print out your bank statements, and sit down for a consultation. A lawyer can look at your circumstantial evidence and tell you immediately if you've a winning case or a total disaster. You don't need to panic just because you didn't sign a form, but you absolutely can't ignore the situation because ignoring a verbal dispute doesn't make it go away. It just gives the other side more time to build their circumstantial evidence against you. Take a deep breath, realize your word can bind you legally, and figure out your next move. You always want to know the exact rules of the game before you step onto the field, and now you know how spoken promises hold up in the real world. What is the most expensive handshake deal you ever made, and did it end up going perfectly or turning into a complete disaster? Drop your story down in the comments. If this breakdown cleared up the truth about verbal agreements for you, share the video with a buddy who is currently stressing out over a promise that wasn't put in writing. Make sure you subscribe to Scribble Law so you always know the actual rules of the game before a broken promise tries to blindside your wallet.